most handsome fellow for Chakasan tribe.
May it please your Lordship.
Yes.
Lordship, I'd like to mention item number 10 from admission.
Item 10.
Lordship, I have served the copy of objection to the
Peter,
appellant counsel also.
just a minute. Yeah.
Lordship, 10, item number 10.
So what do you want, item 10?
Lordship, this matter may be fixed after 3 weeks. I have served the copies of objection to the appellant
Whether
counsel.
trial court record would be necessary here in this case?
No, while deciding the IA now,
IA.
with regards to the IA.
Okay. You have taken consent from the other side?
Lordship.
Okay. You're for the respondent?
Yeah, Lordship, I'm for the respondent 1 and 2.
Okay. Mr.
Imti Wapang, Lordship.
Yes, MT Wapang. Land counsel for the respondent number
1 and 2.
1 and 2 with the consent of the land counsel for the applicant. Praise for listing this matter after 3 weeks.
Lordship.
Okay. Okay. After 3 weeks, then don't write that one. To which the land counsel appearing on behalf of the petitioner has no, applicant has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, Lordship.
Lordship, may I mention item number 5? I'm for a respondent. Lordship, the leading counsel is from Dimapur and is keeping unwell. If this matter may kindly be listed after 2 weeks, I have. taken
Whether
consent
record
from the
was
other
called
side.
for here in this case?
Lordship,
Whether record was called for? Probably the record would be necessary.
record is not called. Right. It's not called, Lordship.
Not called for.
Lordship.
Wait for some time. I'll grant you
Lordship.
adjournment, but let us pass order calling record also. Probably record was not called for till date. Okay, wait for some time.
All right.
Okay.
Obliged.
May I please, Your Lordship?
Yes.
I beg to mention item 30 on behalf of the leading counsel for the petitioner. He's having some personal difficulties, so if it may be listed after 2 weeks.
Item 30.
Yes.
What do you want? You said?
The leading counsel for the petitioner is having some personal difficulties, so if it may be listed after 2 weeks.
No problem. Okay. Miss,
Yuka Kokla.
Land counsel appearing on. Leading counsel is out of station.
having some personal difficulties.
Okay. Miss
Yuka Kokla.
Land Council submits that the leading council, Mr. Santianger, has some personal problem today, therefore prays for adjournment, to which the land, PP has no objection. Accordingly, the prayer is allowed. List this matter. When do you want to say?
After 2 weeks.
After 2 weeks. Okay.
Much obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 8.
Item
8, on behalf of Tiba. Kindly list this matter after 2 weeks,
after 2 weeks.
Lordship.
Here also, probably the trial court record was not called for, it appears. You are for the petitioner.
Lordship, I may bring on behalf of H. Magam, Lordship.
Okay. No objection.
No objection.
Miss
Pichano on behalf of Tiba.
Pichana. On behalf of?
Tipa Pom.
Okay, appearing on behalf of Mr. Kipapong Lana PP. Praise for, when do you want
2 weeks, Lordship.
adjournment of the matter for 2 weeks? To which Miss so Land Council, Miss
Shisa Jamir.
Land Council appearing on behalf of H. Hukam has no objection. Prayer allowed. List this matter after 2 weeks.
Your Lordship, there's an interim.
Para, the interim order passed earlier shall continue till the next date of listing. Okay.
Lordship, similar prayer with item number 31.
31.
Lordship. Kindly list this matter after 2 weeks.
Okay. You have no objection?
No objection.
Okay. To which the petitioner, Land Council for the appellant has no objection. Huh? Accordingly, the prayer is allowed. List this matter after
2 weeks.
2 weeks. Okay.
Are you pleased?
Item number 1.
My pleasure, Lordship. Lordship, this Honorable Court, while order dated 20/11/2025, has directed me to file an application for implement of the complainant as respondent number 2. Accordingly, I filed it on 12/12/2025. Therefore, Lordship, this IA is for implement of complainant as party respondent number 2.
Okay. Implement of the complainant in criminal petition.
Criminal petition 39 of 2025. Lordship, as directed by this court, I've also appeared before the learned trial court on 25/11/2025.
Okay. Mr.
Manchong Punyak.
Land Council for the applicant. The Land Council for the applicant submits that he has filed criminal petition number 39/2025 seeking quashing and setting aside of the orders passed in PRC, case number 01. There are a lot of orders. Orders dated, there are so many orders, 25, 24, 27, 6, 24, 25, 2, 24, 10, 4, 24, 28, 5, 25, no, the 25 only, 24, 6, 25, 29, 8, 25, 10, 10, 25 in PRC, passed in PRC case number 01, 2024. Pending before the Judicial Magistrate First Class, Transam, Nagaland. However, the informant was not impeded in the criminal petition. By filing this application, the applicant seek impediment of the informant, so complainant is respondent number 2 in the said criminal petition number 39, 2025. Okay, so they are necessary party. Then as they are necessary party and as per the direction of this court on 2011-2025. Stop. The prayer is allowed. The para. Complainant Loyam. Only Loyam.
Lordship.
The complainant in PRC case number 01-2024. Sri or Loyam is a name?
Lordship, it should be male.
Male. He is impeded as respondent number 2 in the criminal petition number 39, 2025. Stop with about this IS stands disposal. Okay. Then in the main, hard Mr. So-and-so, in view of the order passed today in IA criminal number 1, 2026. So Loyam. See, what is this address? How would you send the notice in this address? Bajar, resident of Bajar B.
Lordship, it's of Tuinsan
No
district.
house number, nothing. Huh?
There's no house number. However, it's of Tuinsang town.
Yes, respondent number 2. Okay. Stop. The issue notice. The petitioner shall take steps for notice, service of notice upon the respondent, newly implemented respondent number 2 by a speed post with 80 within 5 days from today. Stop. The petitioner shall also amend the cause title by inserting the name of the newly implemented respondent number 2. Okay.
Lordship, there's an interim in the main petition.
In the main. The interim order passed earlier shall continue till the next head of listing. Okay.
Oblige.
For motion, item number 2.
May I please, Lordship?
Yes.
Lordship, this IA number 4 of 2026 is an application under Section 5 of the Indian Limitation Act 1963 seeking for the condition of delay of 12 days, my lord, in preferring the accompanying MSCAP, Lordship.
Will issue notice?
Lordship.
Mr. Medovero, Land Council for the applicant. So this is an application filed under Section 5 of the Indian Limitation Act 1962, seeking for condemnation of delay of 12 days in preferring the accompanying MSC appeal. So issue notice returnable by 4 weeks. The applicant shall take steps upon the respondent, take a step for notice upon the respondent by a speed post with AD within 5 days from today.
Lordship, for 5 days, Lordship.
Okay, 5 days from today. List this matter after 4 weeks. Okay.
Much obliged, Lordship.
Item number 32.
Yes.
Lord, there are three cases here. Yours case supplementary motion. This is in respect that we have challenged item number 15, my lord. 14 of 2025. Item number 15.
Lord, I appear for the Enforcement Directorate. I'm led by the learned ASG, Mr. S.V. Raju. My senior is also appearing.
Item number?
Item number 15, my lord, which is connected with the motion which has come. Because the ED has filed an IA for implement in the predicate offence. Now, yesterday, I have been told that they filed an application for implement, which is about 500 something pages. 26, the copy main petition we have received, but the annexures without the annexures, my lord. At least they should serve a complete set to us.
We will ensure it is served, my lord. We will ensure it is served.
To us so that we can give a reply to it.
Okay, this, otherwise this application is for implement.
Yes, they have filed an
Okay.
application for implement.
Okay, you want to file objection?
Yes, but we have not received the full
okay.
copy.
You serve the full copy then?
We'll,
Then
serve,
only we can file.
we'll ensure it is served.
What about item 6, Mr. Sinha?
Item 6, let the order be passed in number 15, then we can go into other matter.
Will issue notice then? But
No,
you want
already,
copy, full copy?
we will file an objection to it.
Okay,
The court has already given a direction. If your lordship looks into it, a notice has been issued in the main case. That is item number 15 in the main case.
But even on the implementation notice, they were issued.
He said they want to file an application for implement. So they file an application for implement. We have not received the full copy of the full set.
So notice can be issued and he can file a reply.
Should no prejudicially cost him, only notice, simple notice.
notice can be issued since you are appearing?
I'm sorry.
Notice can be issued since you are appearing?
Notice can be issued, but I have to file an objection to it also.
Yes, of course.
Yes.
Of course.
Yes.
This application is filed by, is Bhupesh Arora only?
This application has been filed by ED for implement.
Not by Bhupesh.
My lord, I'll just explain to your lordship. Main writ petition, which is item number 15. If your lordship takes up item number 15, just give it.
It is filed pursuant to the liberty granted by this court, my lord.
My lord, item number 15, the writ petition 41 of writ petition criminal, 14 of 2025. Lordship got it?
14, yes.
Yes. This is the petitioner. I represent a petitioner who have challenged the FIR. We have filed this. We have filed.
Okay.
Now thereafter, the ED appears before the court and they tell that we should be implicated in this case. So accordingly, an order was passed by this court. Please kindly see the order, last
Just a
order.
minute. This writ petition criminal 14 is filed by Bhupesh Arora.
Yes.
Okay.
Now, in this
what is
case,
the last order?
yes. Order to court.
What it says?
Yes.
Para 7, my lord, may see.
You see, para
Order?
9.
Order dated?
On that day, my learned friend did not object to our impleadment. Please see para 7, my lord.
Impleadment by enforcement director as a party in the instant case, to which the land did not object. You did not object.
Yes, and therefore liberty was given for us to file a formal application.
Yes, impleadment has been filed by them. We want to file an objection. Notice may be issued in this case. We will file an
But
objection.
para 7 says that you have no objection.
Yes,
Okay,
to
for
file
filing
an
no
application.
objection. Okay, filing
Filing.
application. But they are necessary party, it appears.
They will file an
Okay.
objection to it. That has to be decided by this court.
Okay. Okay. This has been filed by Deputy Director.
If you see para 7 of the order,
Earlier
and you
order.
see para 7 of the earlier order, my lord, which has been passed by this honorable court. See para 7, my lord, of the order.
Yes.
See, Mr. Joheb, so and so, appearing in the matter, submitted, he may allowed to file an IA for impleadment of ED as a party in the instant case to which the learned senior counsel appearing for the prisoner did not object. Therefore, the ED is given liberty to file an IA for his impleadment. So, accordingly, they have filed.
Heard, Mr. Who filed this?
My lord, Mr. S.V. Raju, ASG, and Zoheb Hussain.
Okay.
We are representing the ED, my lord.
Mr. Joab Hussain, Learned Special PP for the Enforcement Director.
And Mr. S.V. Raju, ASG, my lord. The learned ASG is leading me.
Viraju AST, huh? And Mr. Joab Hussain, okay, Learned Special PP, huh? For the applicant. The applicant filed this petition seeking seeking. You are seeking quashing of FIR also. That is in the main case.
I have filed this petition for quashing of an FIR.
Yes.
So now the ED is appearing against the state. So now ED has come up and filed this application for impleadment.
Okay.
They are saying that they are
implement
in
of the ED.
yes.
Seeking implement of the enforcement director as respondent number 5
Yes.
in WPC criminal number 14 2025 stuff. Issue notice. Since Mr. You are appearing on behalf of the respondent,
I am appearing for behalf of the respondent, the petitioner in this
Mr.
case.
Didas, Lana Senior Counsel. Appear and accepted notice on behalf of the respondent.
In the IA.
Assisted by?
Yes, does.
Okay, Estas. Lana Counsel for the respondent appeared and accepted notice on behalf of the respondent. No formal may be issued. However, the Land Council appearing on behalf of the respondents are misstated. Although the copy has been served upon them, it
Only the petition has been served.
only the petition has been served without annexure.
Yes.
Okay. The petitioner, the applicant shall furnish the complete set of the application to the Land Council appearing on behalf of the respondent within 5 days from today.
Yes, sir.
Okay.
Let them file as fast as possible. We have to give an objection to it.
And the respondent and also submits that they want to file objection on receipt of the complete set of the application. Okay. List this matter after.
It's a 9th, 10th. 10th is okay for you. 10th. Raju, 10th is okay for you all.
10th. Proposing 10th.
10th.
10th is all right, my lord. 10th is all right.
Yeah, list this matter on 10th. Okay.
Please, my lord. My lord, if a copy of the application may be served to us for our reference, state reference.
Yes.
Okay. The copy may also be the same complete set of copy may also be furnished to the state.
State of Ghana.
Okay. The state is respondent.
Yes, my lord.
State is the main respondent here.
Okay, state
They
respondent.
have lost an FIR.
as well. State respondent as well. Okay, within 5 days.
They have lost the FIR.
Yes.
Yes, sir. That's right. So if your lordship now takes item number 9,
May I request my learned friend to begin with item number 6 because I'm not there in item number 9 and I'm called in the Supreme Court in some courts. If you can take item number 6 and finish that. off.
item number 9 can be adjourned because they have not filed any affidavit in this case. That's why I'm saying. Item number reply has not been filed.
We're in the process of filing it, my lord.
So that's why your lordship.
Whether in the item number 9 trial court record is necessary?
Not necessary. Not
Necessary.
Item number 9, they have not filed any objection to it.
Not yet.
So let them file it, and in the meantime, the matter can be posted.
We'll file it in a few days, my lord. In 1 or 2 days, we'll file it within this week.
Item number 9, huh? Heard Mr. Didas, the National Council assisted by Mr. So same, huh? Stop, huh? Also heard Mr. Boat again, huh? Here, who is appearing here in item 9?
Both, my lord, may record
Okay,
both.
again, huh? And praise for father. How much time you require to file affidavit?
Within a week, we'll do it.
Okay, praise for father, 1 week time to file affidavit in opposition. The prayer is allowed. List is matter.
Again on 10th.
Okay, list is matter on 10th. Okay.
Well, I can't say at the present moment whether the records is necessary or not. A scan copy may be, trial court scan copy may be.
Then in that case,
Subsequently, I don't know, subsequently.
10th of February.
Yes.
Okay, then should we call for?
Yes, scan copy.
Okay, then the counsel for the party summons
It might delay things, but if the scan copy is called for, it will delay things. Let it be if necessary on that day, my lords may take a call.
It will come
Really
immediately.
calling for record, etc., delays things. It
Original
delays trial
copy.
court.
All order sheets and applications are already on record. It is not necessary.
Not necessary.
Not
At this stage, your lordship may have a look at
Orders,
it.
we do not know what are the orders.
Then, if it is
So what
necessary,
are
then
the
at that
orders?
date, your lordship may take a call.
Then your lordship can pass an order on 10th.
Yes.
Yes, that-
10th, the matter is coming up. Then your lordship can decide whether records is necessary or not.
Okay, then we'll do.
On
Okay,
10th.
not necessary then. Okay. Yes.
Now we'll kindly take up item number 6, my lord.
yes.
6 also record not necessary.
Record, I think, is not necessary in this case because we have filed for questioning.
For,
My lord will hear it. Then your lordship can make up its mind whether records is necessary or not.
okay, this is also on 10th.
No, I don't know, my lord. This is because this will take some time to argue this matter.
Okay.
Because I'll make it very clear, because it is record consisting of 13,000 documents, the documents which they relied. And we have asked for stay of the complaint. Stay of the complaint that has been passed by the ED till it is decided by this court, because we are seeking for interim order. So now your lordship has to hear it. The interim application has to be heard. I have prepared short notes.
Let my learned friend begin, my lords.
Short notes, but what I am on, my lord, if it has to continue, my lord. If hearing takes, it has to continue. Because suppose your lordship takes it now and thereafter, because I will take some time in this case, my lord. Let me be very honest to it, my lord, so that your lordship may not say that, no, why you are taking so much of time. It is not a matter.
Okay.
I made a note out of it. I can.
It's not a lengthy matter, but my learned friend has the capacity to make it a lengthy matter because of his abilities. I respect his abilities.
For the ED may not be a very lengthy matter, but for the petitioner, my lord, I'll take some time, because 13,000, my lord, they
If it is
prepared-
going to take some time, longer time, then is it okay that ED, the land special PP, appear through virtual? Is it okay? Will it not be difficult? Because
No,
if-
they are virtual itself. They
I
are
believe virtually, it's not required. According to me, it's not required. It's not required that
and a lot of
even if
Yes.
it's not required to read 13,000
Then
pages.
I have to bring
It's not required to read.
It is in. I have to bring all 13,000 pages. Complaint has been prepared with 13,000 documents. Now they want to connect the predicate offence with the ED case, where that PMLA case, predicate offence, they want to connect. So I have to show before this court that whether any case has been made out by ED or not. I have come for questioning of the complaint. The point is jurisdictional point. Point is about jurisdiction. My lord, they cannot connect some other app, gaming and betting, with the HPZ token, which if you apparently when you lordship hears the matter with all the documents and the complaint which they have filed, I can prima facie show before this court that there is no jurisdiction of the ED.
so it doesn't cover under the schedule of offense.
Yes, right. That's what our argument, basic argument will be, my lord. That's our basic argument, my lord. Because, my lord,
My learned friend may decide whether he wants to conduct today or on a next date, my lord. I leave it on whatever date is there. My learned friend may proceed with them. Today also I'm ready. Next date also I'll be ready.
Then, what do you say, on 10th, this also be?
let it be on 10 then.
Let it be on 10th.
Okay.
My lord, my learned friend may give us an advance copy of that note he was referring to, so that we will also file our note. It will make the job of the court easier, my lord.
Now I'll give a note in advance. No problem.
No,
I'll
note
give a
consists of how many pages?
About 3 to 4 pages.
He may give us in advance. We'll file our note as well.
No, we'll give in advance. Before the hearing takes place, one day before we'll give in advance.
Okay, so we'll fix it on the 10th then, this also. Mr. D.
What can I suggest one thing? If it is not inconvenient to my learned friend, 10th this matter can be taken up by this court. Other two matters of a slight longer date can be fixed, my lord. If there is no, so that
Decide on 10th, my lord. Decide on 10th. It can be decided on 10th.
you want to all these two other matters on 10th.
Let it be on 10th.
Let it be on 10th, we'll decide. Very well, my lord.
Okay. Mr. D.
Let- May I leave, my lord? I'm called in some other court.
Senior advocate assisted by same, huh? For the petitioner is present, Mr. So-and-so, land special PP. For the respondents are also present, and then state also is here
My lord, learned ASG, Mr. Raju and Zoe Basar.
on the. As requested by both the land council for the parties, let this matter be listed again on 10th February. Okay?
Yes, ma'am.
The interim order will be considered on date.
On,
because there is
for
No, there's no interim. 16 hearings have taken place. No
Considered.
interim order.
Considered. That's
because
already earlier
interim
order
not
was
yet
there.
considered. It will be
Not yet
considered on that
considered.
day.
Only a day. Yes.
Okay. On which date the interim prayer shall be considered?
Yes. One humble prayer. In item number 9, there is an interim order that will continue, my lord. Item number 9.
There is interim
Yes, there is an interim order, item number 9.
in item 9. Clear. Huh? The interim order passed earlier shall continue till then. Okay.
My lord is passing 3 separate orders, my lord. So that item 9 is different.
No, he is passing an order in item number 9 only.
Yes.
This
My
is
lord
in
is
9
passing
only.
the order in
Fair
item.
enough.
It was in 9 only.
Very well. Deeply.
Okay.
Deeply obliged, my lord. I have to wait more, my lord. Not ED case, I have got another case before your lordship.
Okay.
I will wait because there are other matters.
For admission, item number
I'll take leave, my lord. Grateful.
item number
May I please, Your Lordship?
Yes.
Your Lordship, my senior has some personal difficulties today. If this, my senior has some personal difficulties today, so if this matter can be adjourned for 2 weeks.
Your Lordship, this is a case of 2023. This is a case which was filed in the year 2023, and the case has been pending for long, Your Lordship.
Your senior is?
He has some personal difficulties today, Your Lordship.
Okay. When do you want to say? When do you want to say?
After 2 weeks, Your Lordship.
After 2 weeks. Interim not yet considered. Okay. There is interim order.
Yes, Your Honor. Lordship, there is an interim order.
Okay. Miss
Shisa Jamia.
Learned Council submits that he is senior. Who is your senior?
Mo Jamia.
Moajamir has some personal difficulties today and therefore pray for adjournment of the matter for 2 weeks. To which Mr.
Philip Lorin.
Learned Council for the petitioner has no objection. Prayer allowed. List this matter after 2 weeks. Stop. Para. The interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged, Your Lordship.
for admission, item number 4.
Appeals, Your Lordship.
Yes.
Your Lordship, as per the order dated 15/1/2026, today is for the appointment of the arbitrator. The registry was directed to supply the list of arbitrators appointed by this Honorable Court.
Appointment of arbitrator.
Yes, my lord.
Nice.
the
Is there
arbitrator
any
suggests,
consensus?
arbitrator suggested by the petitioner, His Lordship Justice Retired B.K. Sharma.
The Sharma is not on list.
Yes, Your Lordship, apparently he's not in the list in the latest notification issued by the Zone Court. So
It's only the former judges 6. So is there any consensus between the parties to appoint out of these 6
Your
retired
Lordship,
Supreme Court
since
judges?
there was
or-
no consensus, the now responsibility is cast upon the Zone Court to appoint the arbitrator.
Okay. Should be from former judges of Supreme Court or from the former judges of High Court?
We don't have the list with us, Your Lordship, so if my Lord,
Where the parties are from
Your Lordship, the parties, the petitioner is from Nagaland.
Nagaland.
Then the Union of India, that is, Your Lordship, the respondent number 1.
Subsequently, there are other respondents also.
2 and 3 are again from Nagaland, Your Lordship.
Okay. Earlier, there was only sole respondent, but then subsequently implicated
Yes, Your
some other
Lordship.
parties also.
2 respondents were.
Are they also from this Nagaland or Gauhati?
Your Lordship, Your Lordship, initially, as per the agreement, according to the agreement, the Union of India Ministry of Road Transport and Highways was represented by the Chief Engineer, PWD National Highways, Nagaland. So he was the sole party, but for the convenience of all the parties to adjudicate the matter, we had to implicate the MORT as well as the Commissioner and Secretary, the Department of Works and Housing, Nagaland.
They will appoint one retired judges from High Court, Gauhati High Court then?
Lordship.
May I please, my lord?
Yes.
If I may make a suggestion here, my lord.
Yes.
I may print for representing the respondent number 2 and 3. Now, your lordship, apparently it appears that from the circular issued by the Union of India, the respondent number 2 and 3, that is a state respondent, have actually a very limited role to play as far as even appointing an arbitrator on our own, your lordship, because everything has to be done in consultation with the Union of India. That is what the circular of the Union of India says. Now, your lordship, the name that has been proposed by the petitioner, your lordship, the Union of India has got have not commented anything on that, and therefore this has led us to this final order that was passed, asking this court, this honorable court, asking the list of arbitrators to be presented before it, my lord. Now, if a name can be proposed, and then if the parties can be consented to, by giving us some a limited time.
No, Your Lordship, the question of consent does not arise when the Zolm Court exercises the power under Section 11, Clause 6C. It is the power of the court to appoint, Your Lordship. Since the parties have not come to a consensus, we propose the name of...
Passed. According to this court view that the respondent cannot sit, respondent is inclined to appoint an arbitrator as prayed for by the petitioner. Registry to direct. Registry is directed to place the copy of the notification. Notification has been placed now.
Yes.
So from this notified panel of retired judges,
Yes.
we have to appoint one.
Yes.
So there is a list of former judges of Supreme Court, former judges of Gauhati High Court, and retired district and sessions judges of
Yes.
Assam, Nagaland, and Mizoram also. So we'll appoint one It will be High Court judges, retired High Court judges.
From the names in the notification, Your Lordship, then we have to, this order will have to be communicated to the person concerned.
Yes.
Yes.
Then, my lord, after that, if he agrees, then he can take up the matter. So now our consent, that's already out of question, my lord, because the suggested name has not been agreed to by the parties, because he's not part of the list notified by the Zombie Court.
Then in that case, Your Lordship, my only submission will be if the place of an arbitration is here in the state, taken into convenient of old, Your Lordship. I don't know what instruction the Union of India have. Of course, they are here, Your Lordship.
The retired High Court judges are all from Gauhati, Assam.
Your Lordship.
So only the retired district and session judge Nagaland, there is only one name. He's from Nagaland. And the Supreme Court, probably retired Supreme Court judges are all from outside this state, and yes, some may be from Assam. So you mean to say that we need to obtain consent from the person?
Yes, as per the Act, Your Lordship. However, Your Lordship, the Union of India also is here.
Okay.
Madam Your Lordship. Your Lordship, I'm mentioning on behalf of Your Honor for respondent number 1. Your Lordship, regarding the arbitrator, we have already sent a vetting to the ministry. However, till date, we have not received any instruction for the appointment of arbitrator.
No, the
Your
court
Lordship,
has
the only
decided-
instruction that came is they want to wash off their hands.
Exactly.
No, that
Yes, Lordship.
that
Even
was
in the-
declined.
Yes, Your Lordship. That is.
So then order already passed for appointment only. Now,
Yes, my lord.
now only we have to select a person and obtain consent from the person concerned to whom we are going to
Your
appoint.
Lordship.
Okay.
The place of arbitration, we have to take the consent of the retired judge who is going to
Hard
adjudicate the
Mr.
matter.
Joshua Siddiqui, Direct Counsel for the petitioner. Staff. Also hard Mr. Mr.
Jingyangpong for Your Honor, Your Lordship.
Appearing on behalf of Mr. Yangarvati, Lanet CGSC for the union, and Mr. Enangami, Lanet Senior Government Advocate for the state respondent. Staff.
My lord, can we have a look at the list of arbitrators which my lord is referring to?
Where is this? Is an application filed under section 11, within bracket 6 of the Arbitration and Conciliation Act 1996. Seeking appointment of an arbitrator to adjudicate the dispute between the parties. Stop. Para. Where do I find the agreement where the arbitration clause has also been?
Your Lordship, in the petition,
page 151, my lord.
Yes, Your Lordship. 26.1 to 26.3. More particularly 26.3, my lord.
Dispute resolution. Just a minute. It starts from
Page 151, my lord. 26.3. At the bottom, my lord, we'll see arbitration.
okay. This starts from
It starts from page 16, my lord. Page 16 of the petition. Party's name, my lord, we'll see at
Yes,
page
yes,
29.
Okay. Para. It is submitted, the parties had entered into engineering, procurement and construction, within bracket EPC agreement. Dated, where do I find it? September? Where?
Your lordship, at page 29, 18 September 2020.
18/9/2020. Stop, huh? And page 29.
My lord, the party's name and the date, my lord, we'll see at page 29.
18/9/2020. Okay, stop, huh? Para. And then dispute resolution clause is 26.1.
Yes, your lordship, but arbitration is 26.3.
26.3.
26.3
Yes.
is the arbitration clause.
Okay. The clause 26.3 of the EPC agreement contains arbitration clause. Is it long one? Which is extracted. Here in below 4. Ready reference stuff. 1. Arbitration 26.31. Any dispute which remains unresolved between the parties through the mechanism available stroke prescribed in the agreement irrespective of any claims, value, which has not been agreed upon, stroke reached settlement by the parties, will be referred to the arbitral tribunal as per the Arbitration and Conciliation Act. Okay. And jurisdiction, where do we find the jurisdiction?
Your lordship, under section 26.3, the jurisdiction has not been mentioned.
Where it is mentioned?
Jurisdiction should be towards the end, my lord. Kindly allow me to have a look, my lord. It's not mentioned. Oh, it's not mentioned, my lord.
Okay.
Yes, it's not
Okay. The para, the respondent have filed their or they have not filed objection. Filed objection otherwise?
Yes, Your Lordship.
Have you filed objection?
With regards to appointment of an arbitrator, Lordship, we have already, state has already make it clear that we have no authority to appoint.
Okay.
Yeah, we can only appoint with the, when the central government nominate anybody. We have got no objection to that. To the proposed name given by the Union of India, my lord.
On 15/1/2026, this court observed as follows, and it's para 1 to 3, para 3, relevant. In spite of this, this court has produced the initial agreement which was entered between the parties, and the said agreement shows the Ministry of Road Transport and Highway Government of India represented by the Chief Engineer, PWD National Highway, Nagaland as one party, and the MS Multi Builder as the other party. The agreement was entered into on 18/9/2020 between the parties, as mentioned here in above. Accordingly, this court is of the view that the respondent cannot shift the responsibility at this stage, and this court is inclined to appoint an arbitrator as prayed for by the petitioner under section 11 of the Arbitration and Conciliation Act 1996. Accordingly, the registry was directed to place the copy of notification issued by the, after closing inverted comma. Accordingly, the registry was directed to place the copy of the notification issued by the Gauhati High Court with the panel of names who can be appointed as arbitrator on the arbitrator. The registry has placed a notification number 29 dated issued on 21 May 2024. When did you issue notice?
Notice to, my lord? Which
The
party?
respondent.
The respondents, in fact,
Okay,
the
that's fine, okay.
petition was moved in February 2024.
Okay. Okay, the applicant No, admittedly, the dispute has arisen between the parties in relation to the aforesaid agreement. The adjudication of the dispute is therefore necessary and necessitated by a forum which has been a forum necessitated by the arbitrator. Therefore, Mr. I have no idea the age. This is latest notification. They should be capable. Okay. Therefore, Mr. Justice will propose Mr. Justice H.N. Sharma.
Well,
Your Lordship, if the place of arbitration can kindly be considered, my Lord, because the petitioner belongs to the state.
No,
and
then in that case, place of the Nagaland, then it will be only a district, one, we have no option but only one, who is a retired district and session judge.
Your Lordship, as far as jurisdiction is concerned, it may not be decided today. We'll have to see whether His Lordship, Justice Retired H.N. Sharma, will agree to be the arbitrator or not. That also we have to wait, my Lord. So before the
Lordship, he has been nominated by the High Court. And for the High Court, he has Mr. K. Koza, he has been nominated by the High Court.
Yes, I got district and retired district and session judge.
Yes, since the matter is Kohima and.
Yeah, you agree with that?
I have no issue, my Lord.
Then
as far as the appointment.
we'll propose him then.
If the parties have no issue, I have no issue, my Lord. As far as the appointment
Then we'll
is
say
going to be
agreed
made
by the parties.
Court.
We'll say agreed by the party and we'll propose him.
Your Lordship, as far as the proposal is concerned, this is actually the jurisdiction of this Honorable Court, my Lord. Where we are just submitting that the place of arbitration may kindly be considered. That is just our submission, my Lord.
Okay, then forum which has been agreed by the parties under a aforesaid agreement. Staff. Therefore, Mr. Kape Koza, retired district and session judge of Nagaland, is proposed to be appointed as arbitrator. Okay. Kape Koja, whose name? Kape Koja, retired district and session judge of Nagaland, whose name figure at serial number 15, serial number 15 of the list of arbitrator issued by the Gauhati High Court by notification number 29 dated 21 May 2024. So before finally appointing him, his consent is necessary. Okay, proposed to be appointed as arbitrator. Stop. He may be informed and the registry is directed to inform.
Yes. Your Lordship, not only the registry, we are also supposed to inform the.
It should be through the registry, Lordship. It will be more convenient. It should through the registry.
Through the registry
yes,
only?
Yes,
directed to inform Sri Kape Koje, retired district and session judge, Nagaland, and obtain his consent for appointment as arbitrator. Okay? Then it will be listed after?
After some time, my lord, may fix
3
the date.
weeks, my lord.
After 3 weeks. Okay.
Obliged, your lordship.
For admission, item number 1.
Five. Lordship, as mentioned earlier, LCR was not called, Lordship.
Not called for.
Not called.
Not called for. We'll call for.
Lordship,
Okay.
the same may be called, and if this matter may be listed after 2 weeks.
Oh, okay. Mr. Miss.
Shisajame. Shisajame.
Then counsel for the appellant. And Mr.
James Newman.
James Newman. Then counsel for the sole respondent. Stefan. It is submitted that the in the present case, the trial court record was not called for. However, the same would be necessary for proper adjudication of the matter. In view of the above, let the trial court record be called for. The scanned copy of the trial court record be called for. Stop. List this matter after
2 weeks, Lordship.
3 weeks.
Lordship.
Which court? From which court? Trial court record would be necessary. Which court has passed the impugned order?
Principal District Judge Tiensang.
Principal.
Principal. Lordship.
3 weeks. Is a scanned copy only 3 weeks is enough?
Lordship.
Okay. List this matter after 3 weeks. Okay.
Lordship.
For admission, item number 7.
May I please, your lordship? May I please, your lordship? Your lordship, in connection, so far as this matter is concerned, your lordship, we have filed one writ appeal before the division bench, and in the last occasion, while this matter was being heard, your lordship was, your lordship has
Is there
right-
any stay in that appeal?
Yes, your lordship.
There is a stay.
Yes, your lordship.
Have
We
you
have-
got the?
Yes,
Do
your
you
lordship.
have the order?
Your lordship, for the writ appeal, I don't have a file right now, your lordship. Only the COB is with me, your lordship. And I was also being told that the writ appeal will be listed this week, your lordship. And I was also being told that the writ appeal will be listed this week, your lordship, in the division bench.
Here.
Yes, your lordship.
Mr.
Jingyang Pom, your lordship.
Jingyang Pawlan, counsel for the petitioner. So it will be listed after 1 week.
Yes, your lordship. That's
So
what
you
I've
want this matter to be listed after that?
Yes, your lordship. After the dismissal of the division bench, your lordship.
No, for that you have to show that if there is a stay order. Unless there is a stay order, it will be difficult. There is a stay.
Yes, your lordship. We have
Okay.
filed and stay.
Where is the order? Provide the number. Do you have the number?
Yes, your lordship. For the writ appeal, 28 of 2025, your lordship. And I filed two IA. That is for the condonation and
Could
for
have
stay.
obtained a copy of the certified copy of the order to show that there is a stay.
Yes, your lordship.
And counsel for the petitioner submister that writ appeal being number
28 of 2025, your lordship.
number 28
Of 2025, your lordship.
of 2025
Yes,
has been
Lord.
filed by the respondent. Respondent number?
Respondent number 1 to 5, your lordship. For all the respondents.
Okay, respondents against the judgment and order dated 21/5/2024, passed in WPC number 76/2022, wherein the Honorable Court has stayed the operation of the impugned judgment.
Yes, Lord.
See, are you sure?
Yes, Your
There is a
Lordship.
stay.
Yes, Your Lord.
Therefore, and the matter is,
Lordship, there is no stay. It's still in the limitation stage.
that's why.
Limitation is, delay has not been condoned yet.
Okay, see,
And appeal is not admitted yet.
it will be difficult.
No.
Submit on record. Don't do that. Got it, huh? Leave it. And the matter is fixed for next week.
Yes, Lord.
Therefore, pray for listing this matter after 2 weeks, to which the Land Council for the respondent has no objection. Sorry, the counsel for the petitioner has no objection. Stop. Is prayed for, list this matter after 2 weeks. See, unless there is a stay, this contempt petition cannot differ. Okay, it will proceed.
Yes, Lord.
And don't make such submission unless you have this clear copy of the order. Huh?
We have already filed our appeal in this.
Yes, filing doesn't matter. Whether you, unless there is a stay, this will proceed.
Yes,
The
unless it
contempt-
is state lordship. What by break is that it's condemn is.
Have you filed affidavit? Yeah.
No.
No, you have to file affidavit. Pray for some time if you want.
What Windows lordship, let it come after some time. After some.
Then leave that, huh?
After
Mr.
2 weeks.
Yangarvati Land Council for the respondent prays for further 2 weeks' time.
Yes.
To file. And then you have obtained instruction.
No, I have not filed Wakalat demand on behalf of respondent number 1. I'm yet to file my Wakalat in the 7th in the contempt petition.
You have not yet filed Wakalat Nama.
Yes, for respondent number 1.
1.
Yes.
And what you have filed Wakalat Nama?
We have already filed on behalf of 2, 3, and 4.
Okay.
And 1, I'm waiting for the.
And you are for?
Yes, it's my genealogy.
Okay. Then
Yes.
you are for the petitioner. Miss?
Asan Jamil.
Leave those. Land Council for the petitioner is present. Stop. Mr. Yangarvati. Land Council appearing on behalf of the respondent number 2, 3, 4, and 5.
Yes.
Submits that he has received an instruction to file affidavit in opposition. Affidavit. However, he is yet to file Wakalatnama on behalf of the respondent number 5.
1.
Sorry,
One.
respondent number 1. And prays for, accordingly, he prays for further 2 weeks' time to file Wakalatnama on behalf of respondent number 1, affidavit on behalf of all the respondent. Okay? The prayer is allowed. List this matter after 2 weeks. Okay.
For order, item number 11.
May it please your lordship, I for respondent 3 and 4. And since my senior is indisposed, your lordship may kindly list this matter after 3 weeks.
But it is for,
We'll list it for,
IA
get
for-
listed for,
IA hearing.
oh, IA is for what?
This is for appointment of survey commissioner.
Okay. But then that can be heard together
No, it
at
has
the
to
time
be
of final hearing.
IA has to heard first.
IA,
Yes.
if it consider, because this is
Yes,
connected
yes.
with the main case,
Main
merit of
case,
the case. This
It
cannot be taken up separately.
It has to be, first, the IA has to be taken up.
Now, if we go for ascertaining whether, what was the prayer?
For Appointment of survey commission.
There is a praying for issuance of investigation. Whether the appellant plaintiff encroach the lane of the defendant. See, this amounts to, this will amount to go, if we decide, or if they decide, it will amount to decision of, on the merit of the case itself.
Yes, Your Lordship. So, Lordship, the IA as well as the main petition may be listed after 3
It
weeks,
will
Your
have to
Lordship.
be taken together.
Yes, Your Lordship. So let it be listed after 3 weeks, Your Lordship. Mr. I. Longjam, he's indisposed, Your Lordship. He will be arguing this case, Your Lordship. Mr. Imti Longjam is going to argue his case, Your Lordship, and he's
Okay.
indisposed, Your Lordship. So if this matter may be listed after 3 weeks, Your Lordship, along with the IA.
Also, can you fix on fifth as a fixed item? Yes, 5th February.
So this is in order. We'll get it listed, the main appeal for, has it been admitted?
Yes, yes.
Yes, Your Lordship.
Okay. Then for hearing?
Yes.
Yes, Your Lordship.
Okay. Heard Mr. NK. Welcome, Land Council for the applicant. I've also heard Ms. Esther, Land Council for the respondent. How many
3
respondents?
and 4, Lordship. 3 and 4.
3 and 4. Who is for 1 and 2? You're for 3 and 4 only.
Yes, Your Lordship.
Who is for 1 and 2? Who represented earlier?
State.
It's private.
State.
State.
Actually,
State is 3.
State is 3 and 4. State is 3 and 4.
No, Esther, you are for 1 and 2.
I'm for 1 and 2, Lordship.
State is
My apologies, Lordship.
So I was supposed to go.
And Ms. Sukri for Learned Additional AG for state respondent number 3 and 4. They start for 1 and 2. Okay. Para. This is this application has been filed under order 41 Rule 27, read with Order 26 Rule 9, read with Section 151 of Code of Civil Procedure. (1908). Seeking issuance of praying for issuance of commission for local investigation into the matter to ascertain whether the land purchased by the plaintiff stroke applicant and the defendant number 3 stroke respondent number 1 are the same land, and as to whether the appellant stroke plaintiff has encroached the lane of the defendant number 3 stroke respondent number 1 staff. You have filed an objection?
Yes, they are filed. Already filed.
the respondent has filed objection contending that the application under Order 41, Rule 27, read with Order 26, Rule 9, read with Section 151 of CPC, is not maintainable as and the same ought to be considered the as along with the second appeal and cannot be heard separately. Along with the second appeal. Stop. Para. At this stage, this court is of the considered view that issue raised by the applicant are connected with the merit of the second appeal and the necessity or otherwise of the additional evidence could be or local investigation into the matter can be appropriately examined only at the time of the final hearing of the second appeal. Start. Para. Accordingly, the appeal according to the application under Order 41, Rule 27, read with Order 26, Rule 9, read with Section 151 of CPC. Shall be considered along with the second appeal at a stage of final hearing. In view of the above, this matter, along with the second appeal for hearing.
Can it be on 9, my lord? On 9th.
Staff. And as requested by the parties, that this matter be listed for hearing on 9th February.
In that case, your lordship, then it should let it be on some other day, not 9.
Okay, when?
10, lordship.
No. 12 or 12?
12, okay, 12. 12 February. Okay.
Much obliged.
For orders, item number 12.
May I please your lordship? Lordship, service upon respondent number 4 is still awaited.
Ms. Ayala Imchen, Land Counsel for the petitioner, is present. You are for?
Respondent number 2.
Ms.
Kim Piana.
Land Counsel, appear on behalf. Have you filed affidavit?
Yes, your lordship.
Okay. For the respondent number 2 and
Only 2.
2
Yes.
is also present. Staff, however, the return service upon the respondent number 4.
Yes, Lordship.
What about others? It is still awaited. However, the office note dated 15/1/26 reflect that the return service upon the respondent number 4 is still awaited. In view of the above, let this matter be listed. What about the others? Other respondent?
Respondent number 1, Tiba Bom is appearing for respondent number 1.
2 also appeared. Yes, 2 also appeared. What about 3?
Lordship, for respondent number 3, respondent number 3 has been transferred, so respondent number 4 has been.
Okay. 4 still awaited in view of the above.
Lordship.
Let this matter be listed after 2 weeks.
If we may be allowed to take first steps upon respondent number 4.
4, okay. Then still awaited. Ms. Ayangla, Line Counsel for the petitioner, praise for allowing her to take fresh steps upon the respondent in view of the above. Ms. Ayangla, Line Counsel for the petitioner, praise for allowing her to take fresh steps upon the respondent number 4. Prayer allowed. Step upon the respondent number. Step for service of notice upon the respondent number 4 by a speed post with AD within 3 days from today. Staff, list this matter after 3 weeks. Okay.
For order, item number 13. May I please, my lord?
Yes.
Lordship, in this matter, I am appearing for respondent number 1 and the newly completed respondent number 5.
You have filed?
No, Your Lordship.
Not yet.
Yes, if some time can be granted to obtain the necessary instruction, my lord.
Mr. Anangami, Lana Senior Counsel, appearing on behalf of the respondent number 1 and 5. Praise for how much time?
3 weeks time, my lord.
For the 3 weeks time to obtain necessary instruction to file affidavit. To which the Land Council for the petitioner has no objection. Petitioner, Miss?
I'm allowed, yeah.
Has no objection. Prayer allowed. Have you filed? You are for?
I'm for appearing on behalf of my senior for respondents 2, 3, and 4.
Have you filed affidavit?
No, Your Honor.
Okay. Miss? You are Miss?
Tamsi Jamir.
Appearing on behalf of respondent number 2, 3, and 5.
2, 3, and 4.
2, 3, and 4.
On behalf of my
Made a
senior.
similar prayer. Staff. Appearing on behalf. Who is your senior?
Mr. Astamjan.
S. Tenjian. Made a similar prayer. The prayer not been objected by the Land Council for the petitioner. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged, Your Lordship.
For order, item number 14.
Granted 3 weeks time to file affidavit.
Yes, Lordship. Lordship, as per the order of this Honorable Court, dated 1811, my Lord, I was directed to take steps upon the respondents 3, 4, and 5, 3, 4, 5, and 6 through dusty service. I have taken the steps and I'm yet to file my affidavit for taking dusty service. So I may be allowed 2 weeks time to file my affidavit for causing service upon them.
Mr. Prosecutor for the Land Council for the petitioner submits that he has taken steps upon the respondent number
3, 4, 5, and 6.
3, 4, 5, and 6 by way of dusty service. and press for some time to file compliance affidavit. Prayer allowed. List this matter after?
2 weeks.
2 weeks. Okay.
Lordship is an interim. Can let
The
the interim
interim
continue.
order passed earlier shall continue till the next date of listing. Okay.
Highly obliged, my lord.
For orders, item number 16.
My lord.
Yes.
My lord, I've taken by order dated 11/12/2025.
Yes.
I've taken steps upon respondent number 8, the private respondents.
Mm.
Till date, the respondent number 8 has not been represented.
Okay, Mr. Poseko for the Lana
More-
Council for the petitioner.
Your Lordship, here the main challenge is against the action of the investigating authority. So I think the presence of the state will suffice. Because on several occasions they have been taking adjournment on the ground of non-service. And
Motion,
they are
Lordship.
enjoying the interim, so they cannot enjoy the interim indefinitely.
Moreover, Lordship, motion was on 24/6/20.
Have you filed your objection?
Yes, yes.
Lordship,
Way back last August.
Lordship, I'm yet to file my reply to the objection filed by the respondents.
You filed reply then?
Yes.
Lordship, kindly grant me some time, Lordship. Sufficient time, Lordship.
Okay, concentrate on filing reply then.
Lordship, kindly,
If
Lordship.
the state is on. Okay. Mr. Fusiko Pate, Lana Council for the petitioner. Praise for father. How much time?
Lordship, it's 4 weeks, Lordship.
3 weeks' time.
4 weeks,
3
Lordship.
weeks' time, Your Lordship.
Lordship, here I'm
That
led
is-
by
To file affidavit in reply to the affidavit in opposition. So filed by the respondent number 1 to 6. 7 also filed, already filed?
70 yes, they have
Yes,
filed.
they have
CAG
filed.
has filed.
Oh, and respondent 1 to 6 and respondent number 7 respectively. So the prayer not being objected to by Ms. Marilana BP is granted. It is allowed. Stop list this matter after 3 weeks. Okay.
Lordship. Lordship, it's interim, Lordship.
The interim order passed earlier shall continue till the next year of listing. Okay.
Highly obliged, my lord.
For orders, item number 17.
May I please, Your Lordship?
Yes.
Lordship, as per the last court's order, service upon respondent, I've taken steps upon respondent number 6, as per the last court order.
Hmm? Respondent number?
6.
May I please, Your Lordship? Lordship, for respondent number 6, Lordship, I have instruction to appear. So
Okay.
I will be filing my Bakalat number.
Have you filed?
No, Lordship.
Okay.
Within this week.
Okay. Then, Ms. Ayala, Imtian Lana Council for the petitioner, stop. Now, who appears for the other respondent?
I am only appearing for respondent number 6.
You are only for respondent number?
Respondent number 6.
6.
Lordship.
Okay, who is for the other? Have they appeared?
Lordship, another party in this matter, I'm appearing on behalf of M. Solo.
Hmm?
I'm appearing on behalf of M. Solo.
Okay. You are for M Solo.
Yes, Lordship.
Okay. There are other respondents. Just a minute. Okay, Mr. Jimomi, Learned Council, Mr. Jimomi, Learned Council appeared on behalf of
Respondent number 6.
respondent number 6 and prays for some time to file wakalatnama.
Lordship.
So, 1 week.
Lordship, let it come after 3 weeks,
You,
Lordship.
you,
In the
you file
meantime, I will
affidavit
file
at the
my
same time?
wakalat.
Okay, and to
Lordship.
file affidavit.
Lordship.
What about the other respondent? Tree also appeared, no? Appeared earlier. The prayer is allowed. List this matter after 3 weeks. Okay.
For orders, item number 18.
Not yet filed.
May it please your lordship. Lordship, here the respondent number 1, 3, 4, 5, they are duly represented. But lordship here, regarding the respondent number 2, lordship, the notice are still awaited. However, lordship, we are informed that the officer has been transferred. So kindly grant us some time to file IA to implement the respondent, the new incumbent, lordship.
Ms. Nika, Dana Council for a petition submits that she has an information. She had received an information that the respondent number 1, 3, 4, 5.
They are represented, lordship. They are
Okay.
here.
They have been transferred.
Oh, no, just 2, lordship.
2, okay.
Yes, lordship.
The respondent number 2 is, has been transferred, and he therefore prays for some time. And in his place,
The newly incumbent officer has been
The,
posted, lordship.
some other officer has been transferred. Therefore, prays for allowing her to complete the newly officer transferred in place of respondent number 2. Stop. And you are for?
I am for 1,
Mr. Angami for respondent number 1, and who's
Lordship, I'm for 3 and 5.
Ms. Sukri for 3 and 5, and
I'm for respondent number 4.
okay, Jimomi for respondent number 4 are also present. And have you not yet filed?
I have filed.
You have filed? No, affidavit you have filed?
No.
Okay. And prays for how much time? For the 3 weeks time.
Lordship, let her first include respondent number 2.
Okay. Prays for some time. The prayer is granted. In the meantime, you file implement petition. Okay.
Lordship.
List this matter after 3 weeks. Okay.
Much obliged.
Much obliged, lordship.
For orders, item number 19.
May it please your lordship. Lordship, on behalf of Livica, she have instructions to appear for the sole respondent. On behalf of Livica, she have an instruction to appear for the sole respondent.
Lordship, here we have actually received this order from the respondent.
What is that order?
Lordship, here they're asking for some documents from us, from the petitioners, to consider her case. So since they're actively considering, it may be closed
Okay.
with instruction to finish the process within a certain time period with directions, Lordship.
So the government is issued this.
Yes, this is.
Are you not? Are you aware of it? No.
No,
They just obtain instruction. This will pass order tomorrow or day after tomorrow.
Lordship.
Okay. You have for respondent number?
For respondent number 1 on behalf of Liviga Law.
Okay, Miss. You are
There's
Miss.
only one respondent. I'm for the petitioner, Lordship.
Okay, Miss.
Obang Nanla Longcha.
Okay, then counsel for the petitioner is present. And some is that in the during the pendency of this contempt petition, the government has passed some interim order. However, Miss Vichano,
Lordship.
appearing on behalf of Miss Liviga and counsel for the respondent, some is that she is not aware of the said order and prays for some time to obtain necessary instruction in this regard. Prayer aloud. List this matter on Thursday.
Okay.
Obliged, Lordship.
Okay.
Lordship, here also similar
Similar order.
developments.
Okay, similar order. Huh?
Lordship, this may be placed on record.
Yes, yes. Then right here, like this, hard so and so, and some is that in the meantime, during the pendency of this contempt petition, the government has issued some interim order. What is this interim order for? Interim
It
order.
is just stating that they are pursuing the
Okay.
matter.
Interim order. Okay.
And we will also be submitting the documents they have sought for in the meantime.
Whether you have been directed?
Yes, Lordship.
Okay. Whereby the petitioner has been directed to submit certain documents to consider their case. Stop. And then Ms. Pichana appearing on behalf of Ms. Liviga, some is that she has praise for allowing her to obtain instruction in this regard. Stop. Prayer aloud. This matter on again on Thursday. Okay.
Obliged,
I
Lordship.
pledge.
For orders, item number 21.
May I please, my lord?
Yes.
Lordship, I have instruction to appear for respondent number 1 in this matter. If some time can kindly be granted, my lord, to receive the necessary instruction.
Okay. Miss
Shisa Jamil.
Learning Counsel for the petitioner is present. Mr. Angami, and Angami, Learning Counsel would appear on behalf of the respondent number
1, my lord.
1. And have you filed wakalatnama?
No, Your Lordship. I'm
And
appearing
praise
for the first time
Okay,
today.
praise for some time to file wakalatnama and to file affidavit if necessary. Okay.
Lordship.
Prayer allowed. List this matter after 3 weeks.
Obliged.
For orders, item number 22.
Lordship, even in this matter, I have instruction to appear for respondent number 1, my lord.
Okay. 1.
Yes, my lord.
You are Mr. Jimobi.
Lovikatosu. Lovikatosu.
Okay. Mr. Lovikato Su, Learning Counsel for the petitioner is present. Mr. Nangami submits that he has an instruction to appear on behalf of the respondent number 1 and prays for some time to file wakalatnama and to file affidavit if necessary. Okay.
Lordship.
List this matter after 3 weeks. Okay.
Deeply obliged, my lord.
For orders, item number 23.
Your Lordship, we have taken steps, but completion upon the sole respondent is still awaited. And today is the first reasonable date. So if it may be listed after 4 weeks.
Okay. So record says that you have not taken steps. When did you take steps?
Last year. Last year, after the court order.
No. The record says that you have not yet taken steps.
It's not yet completed.
13 January.
It's not completed. We have taken steps, but it's not completed.
No, what I'm saying is you have not yet taken steps. You probably have to take steps.
Okay.
Not yet taken. The record says it's 13-1.
We will
check
take fresh steps.
Miss?
Yes, Your Lordship. We will take Yuka Kokla.
Luka?
Yuka Kokla.
Okay, Land Counsel for the petitioner submits that she has taken steps upon steps for notice upon. How many respondents are there?
1.
So notice and tell about it. Service notice upon the respondent number, respondent. However, the office note reflect. Office note dated 13/1/26 reflect that the steps has not yet taken. The petitioner has not yet taken steps for service of notice upon the respondent. The petitioner said, check and ensure that step is taken upon the respondent. Okay?
Much obliged.
Or if not taken, you take steps. Check it, and if not yet taken, you take steps. Okay? If not taken, the petitioner said take steps.
For order, item number 24.
Lordship, similar prayer for item 24 and 26. 25, 24, 25.
24?
25.
These are same?
Yes.
Okay.
23, 24, and 25.
Here also same?
Yes.
Okay, and the office note dated, she submitted taken step, but however the office note dated 13/1/2026 reflect that the petitioner has not yet taken steps upon the respondent staff. The petitioner said verify and take steps upon the to take steps for notice of service of notice upon the respondent within 5 days from today. Okay? If not taken, huh?
For orders, item number 26.
Please, Lordship. Lordship, in this case, I have instruction to appear for the respondent number 2, Your Lordship.
Your Lordship, I'll be appearing for respondent number 1. I'm here to file my double number. And we allowed some time. 2 weeks.
So you'll be filing objection?
Yes, Lordship.
Okay. Miss. Okay. Which channel and counsel for applicant is present? Mr.
Medavero for respondent number 2.
Medavero for?
Respondent number 2.
And you are for?
Zed Kulu for respondent number 1.
Okay, Jed. Jed?
Kulu for
Kulu
respondent number.
would appear for respondent number 1 and Mr. Medavero for respondent number 2 and press for
4 weeks time, Lordship.
Wakalatnama and to file objection if necessary. Stop. The prayer is allowed. List this matter after 2 weeks.
Oh, 4 weeks, Lordship.
After 4 weeks.
Lordship, Lordship.
Okay.
Much
obliged, Lordship.
For orders, item number 27.
Yes.
May I please, Your Lordship?
Yes.
Lordship, this IA is for implementment. For implementment.
For implement.
Yes, of respondent number 4 and 5.
Okay. Affidavit is yet to be filed. Have you notified?
No, Lordship.
You have to bring on record. Regarding the order in question, huh? Have you notified?
No, Lordship.
You have to, I think. There is an order
Yes, Lordship.
directing you to notify. Miss Sangla, huh? You are Miss Aseng, huh?
Ayala Imchen.
Oh, Imchen, na? Praise for Father. How much time?
2 weeks.
Father, 2 weeks time. To notify the proposed respondent regarding the order in question. As per the order dated 2/12/2025, prayer allowed. List this matter after 3 weeks. Okay.
For orders, item numbers 28 and 29.
May I please, my lord? Lordship, I have instructions to appear for respondent number 2 in the criminal petition, Your Lordship.
Item?
Item number 28 and 29. For 29, I have instructions to appear on respondent number 2, Lordship.
Appearing for the first time?
Yes, Your Lordship.
I'll just explain to your Lordship, my lord. My learned friend is appearing under 29
Yes, sir.
and 28, 29. I'll just tell your Lordship what is, there is an order passed by this court. I'll just read this order. My lord, just don't open, I'll just tell.
Okay.
This is an FIR which has been lodged by my learned friend's client against 3 of the accused. One of the petitioner is one of the accused, alleged. So now, this was put to challenge by us before this honorable court. Now, what is the case, my lord, of the informant? Somewhere in 2010, an amount of 5 crores in cash was paid to one late Arun Batoria, not to any of this petitioner, to one late Arun Batoria in 2010. He died in 2011. Now in 2025, and a receipt has been annexed in the FIR, and he said that this money has been paid to late Arun Batoria in somewhere in 2010. Now they could not repay the amount. In 2025, this FIR has been lost. So your Lordship will kindly see from 2010 till 2025.
FIR laws against?
Against the petitioner and two others.
Who are they?
They are Mr. Bhutoria.
Now, who are they to the...
They are not before this court. They are not before this court. I have come for question only the petitioner.
Okay,
Who are the petitioner?
How the petitioner is connected with the person?
The petitioner is nowhere connected. Nowhere connected.
The person who is alleged to have received five
No, nothing, my lord, nothing. That is why the court has protected us. This High Court has protected us.
Okay.
I'll show it. That's why I'm telling. No case has been made out. We showed 2-3 judgment of the Supreme Court. Very clear. Judgment of the Supreme Court says that it is only a commercial transaction.
Okay.
There cannot be a criminal cheating or 409.
Okay.
If it has been stated in the FIR that you pay, I am paying you a sum of rupees 5 crores, and if you as a loan, and when loan is returned back, but pay a 30% profit of that amount, pay 5 crores. So this is Supreme Court said these are absolutely a commercial transaction. So we file a criminal petition, my lord, which is before your lordship for questioning of the FIR. Item 29. Now, what is the order that has been passed by this court?
What happened to the FIR? Whether the investigation?
No, that's what I am showing, my lord. If your lordship kindly see the order, order of this court. Please see the order of this court. 10th of December 2025. 10th of December 2025. Lordship got it, my lord?
This is I. Yes.
10th of December. Lordship got it? I'll just read it slowly, my lord. 10th of December.
Okay.
See para 3, my lord.
Okay. Anyway, the investigation, no coercive action against
Yes,
the
yes.
petitioner.
My lord, please see that para 3, my lord. Para 3. Para 3 of the order. Para 3. May I read this para 3, my lord?
Yes.
It is submitted by Mr. Das, learned senior counsel, that the case of the present petitioner was initiated on a transaction of money in the year 2010 with one Arun Bhutoria who died in 2011, where there was a transaction of 5 crores. And as per the statement made in FIR, all these transactions were in cash, and the present informant was assured that he would be paid 30% of the profit of the said amount given. The transactions were purely commercial and not a case of simple entrustment of property or money. Rather, it is a commercial transaction where it was promised to pay 30% profit to the present complainant. But from the money receipt, which was given in the letter pad of the complaint, it reveals that the entire transaction was taken place in presence one Pradeep Agarwal, and in this letter pad, there is no mention at all about the presence of the petitioner, who is stated to be one of the directors of the company, namely EPCON. But the said Arun Bhutoria was not a director of the said company at the time of transaction of money, and what has been done was purely a personal transaction. The petitioner name was not even present at the time of transaction, but only for procuring money, the name of the present petitioner, along with 2 directors named, has been mentioned in FIR. The entire transaction was completed in the year 2010, but after a long 15 years, the present FIR has been lost in the year 2025. Learned Senior Counsel further submitted in the year 2023. After 13 years, a GD entry was made, but it was kept in abeyance as some assurance was given from the accused person, and subsequently the FIR has been registered only in the year 2025. Further, Mr. Das, Learned Senior, submitted. These are all oral submission from the informant, but there is no documentary evidence except the money receipt to substantiate the plea of the complainant that a transaction was completed in the presence of petitioner who is one of the directors of the company, namely EPCON. Further, it is submitted that as per one notice under section 35(3) BNSS was stated to be issued on 14/10/2025, directing the present petitioner to appear before the IO on 31/10/2025, but the present petitioner never received the notice under section 35(3) BNSS, and he is presently in the US after the miscarriage of his daughter, and since August 2025 he is in US, but without even receiving the notice, an order of issuance of NBW was procured by the IO, and subsequently by an order dated 2/12/2025, London magistrate had withdrawn the NBW which was issued earlier against the present petition. Further, citing the judgment of the Honorable Supreme Court in so and so, it is submitted, Mr. Das, that there is no ingredients to attract neither section 409 or nor 406 as registered against the present petitioner, and that law clearly recognizes the difference between simple payment, investment of money, and entrustment of money or property. But here in the present instant case, as it is seen from the FIR itself, that it was purely a commercial transaction wherein the informant was assured to give 30% profit by late Arun Botoria. Thus, there cannot be any case against the present petitioner under section 406, 409 IPC. However, it is submitted by Mr. Das, present petitioner is still ready to cooperate with the IO in compliance with section 35(3) BNSS, and he may be, my lord will kindly take this paragraph may be interrogated virtually as he is present staying in US. Mr. Das further submitted, no coercive action may be taken against the present petitioner as he is ready to extend his cooperation. 7. So and so the learned public person Nagaland has submitted the case is still under investigation and his presence is required for his notice under section 35(3) BNS has already been issued against the present petitioner. But despite of the notice issued, the petitioner is not cooperating IO, and hence his physical presence may be required for the interest of investigation. Now the operative portion of the order. Considering the entire submission made by learned counsel of both sides, and on perusing the case record along with annexation of the petition, IO is hereby directed not to take any coercive action against the petitioner. However, the accused petitioner is hereby directed to extend his cooperation with the IO of this case. However, till his return from USA, he may interrogate it or his statement be recorded by IO through virtual mode. Now, my lord will kindly see para 9. However, the IO will also make enquiry in compliance with section 35(3) BNSS after his physical presence before the IO, preferably within first week of February. Issue notice so and so, so and so. So now there are three things, my lord. One, I am protected, there no coercive measure. Secondly, my submission, my statement may be recorded to virtual mode. Now what has happened thereafter, my lord? Thereafter, my lord, I am in pursuance to the court order. If your lordship takes the IA, item 28, please take this IA, my lord. Why I filed this IA? Now, please take IA and statement I made. Para 3 kindly be seen, my lord, of my IA 2 of 2026. Para 3. That applicant state, lordship got it? Page 4, para 3, my lord, of my IA.
Yes.
The applicant state and submit that after passing of the interim order dated 10/12/2025, which I read, my lord, the applicant wrote an email dated 16/12/2025 to the officer in charge Suburban Police Station, Dimapur, along with a copy to the Nagaland Police communicating the order dated 10/12/2025 passed in criminal petition, this honorable court, and also requested for his recording his statement through virtual mode as per the direction of this honorable court. Now, my lord will kindly turn to, this is what we have annexed the email, my lord, annexure B. That is the first email which we have sent. If your lordship looks into the first email at page 17,
Yes.
page 17 down below, page 17 down below, that is the first email down below. 16th of December, to so and so request to record my statement. through virtual mode, Honorable Court's order dated 10/12/2025, criminal petition number 43. Lordship, got it, my lord?
Yes.
Now please see next paragraph, paragraph 4 at page 5. Paragraph 4 at page 5, my lord. The applicant state and submit that as no reply was forthcoming from the police authority, applicant again on 9/1/2026 wrote a follow-up email requesting the officer in charge, Suburban Police Station, Dimapur, for recording his statement through virtual mode as per direction of this Honorable Court. However, till the date of filing this instant application, no response has been received from the police authorities. Now, please turn to page 17 again, my lord. My response is of, if you see on the top, Lordship got it? Reminder, I so and so accused number 2 in Dimapur so and so write to respectfully follow up on my earlier request through email dated 16 to record my statement to virtual mode in terms of the order passed by Kohima bench of the Honorable Gauhati High Court. As I am present in United States due to bereavement in the family, I request that a suitable date and time may be fixed for recording my statement via video conferencing and that the VC link platform details Google Meet, WebEx, Zoom, or as per departmental protocol be shared with me at the contact details below. So my contact was given below. So I has come up with an IA, my lord, and also my lord, and also we have attached the order of the court. So why this IO has been filed? The order we have annexed, we have come up so that the order may be complied. So they may record my statement to virtually. And one difficulty is there. Please look into the order we have annexed here also, my lord, in this petition. If you see at page 16 of this IA, kindly see para 9, my lord.
Yes.
However, the IO will also make an inquiry in compliance with 35(3) after his physical presence before the IO, preferably within first week of February. Now, my lord, there is difficulty of this petitioner. I have written and there is a statement which has been recorded that he's given the daughter stillborn baby miscarriage. So that is why the court considered and court said a virtual mode his statement may be recorded. And this I have come up with a prayer that this portion, paragraph 9, may be kept in abeyance, my lord, and my statement may be recorded. Physical. Now I have got exactly a judgment of a Supreme Court, my lord. Same. The Supreme Court said, my lord, I will show the judgment exactly on the same point. First, Supreme Court said virtual mode and application 482 has been filed and his presence should be kept in abeyance. Till my statement, I will cooperate, my lord. It's not that I will not cooperate. Please record my statement. That's the order passed by the High Court.
I think this, let the February come and then if there is a difficulty, you make
No, what I'm saying, please see the order of the Supreme Court. One order of the Supreme Court. Please see the order of the Supreme Court 2020, my lord. Please see para 8, my lord. Para 8. See para 8.
Yes.
Lordship got it, my lord?
Yes.
We should not at this stage be construed to have expressed a view on the merits of the petition for quashing, same, my lord, which is pending before Calcutta High Court under section 482 of the Code of Criminal Procedure. Same we have filed. The mere filing a petition to question FIR under section 482 is not sufficient in and of itself to obviate compliance with a summon under section 41A. Now your lordship knows it is 35 of BNSS. We are, however, of the considered view that to require the petitioner at this stage to comply with the summon under section 41A during the pendency of the proceeding before the High Court would not be justified in the facts as they have emerged in this case. Because no coercive action here also, my lord. Hence, we grant an interim stay against the implementation of direction of High Court requiring the petitioner to appear before the IO at Baliganj police station. This is subject to condition that the petitioner undertakes to respond to any queries that may be addressed to her by the IO, and if so required to attend those queries on the video conferencing platform with sufficient notice of 24 hours. Mr. Jetfanani, learned senior counsel appearing on behalf of the petition state, petitioner would cooperate in all respect, though after the order of 5th June, no query was addressed to the petitioner, despite 5 months have elapsed since then. So here is also same case, my lord. I responded, no reply. My lord, here the Supreme Court has said that exactly same case, my lord. I am not saying that video conferencing already they can do it, my lord. Give a notice to me.
Now see,
Yes.
video conferencing not yet done.
Not yet done, one.
So let them do first.
Correct, right.
Because probably there is a difficulties, but then if they do, they may also satisfy with it, not required to
No, that's
be
why I'm
physically
saying.
present also.
No, the problem is that unless your lordship has to give a direction, then let them take
No,
a video
what I'm
conference.
saying is because they are yet to do is virtual, okay?
But they have not done it.
No, not done it, not
Yes.
yet done it.
Yes.
After virtual, they may
But
also
that,
satisfy with
no,
that.
no, that is
virtual.
what I am saying. Your lordship is
And
right.
on the because you will have time, enough time, and because they might not do within a week or two, probably. Even if they do also, then make a
No,
request.
my lord,
these are my difficulties.
No, now when we moved this matter, before your lordships came here, last week on Friday, on Friday, it is on 16/1/2026. We moved the matter, my God, because there was insufficient time, because we filed it. See this order. Heard Mr. So learned senior
Yes.
counsel, assisted by so and so, learned public, the learned has praised for time to open. This is matter on 19/1. Interim order passed. So number one, then instruction. Number two, this on IA. Number two, that it has been fixed on 19/1, my lord, today, to obtain
No,
instruction.
See, so
No, today he is a man of 60.
After what I'm saying is after the virtual is done, make a request there. His physical presence may not be required
No,
also.
that's what I'm saying.
But then,
Absolutely, your lordship is right. Your lordship, I agree to it. Let them, number one, your lordship has said rightly, let my statement may be recorded virtually.
First.
Number two, till my statement recorded, my physical presence may not be required as per direction of the Supreme Court.
Okay, virtual is.
That's why. But
okay,
virtual,
okay.
then my
That
presence
can-
may
that
not.
can-
It
that
is
can
first week of February, not possible. He is in the US, my lord. My physical presence, that way your lordship will pass necessary order thereafter.
Okay.
IA is only my learned friend is appearing.
So I think that is fair enough because the police has not yet recorded the virtual. First, let the virtual be recorded first.
Lordship.
And then unless the virtual is recorded, because here by this order, the physical is required physical in the first week of February. So unless the virtual is recorded, first week of February comes, then
Yes.
he may be required to physical before virtual. So let the virtual be recorded first.
Lordship, on the last occasion, this Honorable Court has directed the state respondent to produce the case diary, scan copy of the CD.
Okay.
Lordship, from the CD, Lordship, if I'm allowed to place the CD.
Okay.
Lordship, from the CD, it appears. Lordship may kindly look at the last page, dated 16/1/2026. That is the last page. Last page, the last page, third line. Dated
Last page?
Yes, Lordship, which I have flagged. Note, if I'm allowed to read, Lordship. The Honorable Court has directed the accused Milan Shah be examined through virtual mode. However, the said virtual examination could not be conducted as no valid contact details were furnished by the accused to enable communication or facilitate such examination, number one. And secondly, very important, Lordship. Further, upon scrutiny of the call detail records, CDR, it was revealed that a mobile number of the accused Milan Shah remained active till 18/10/2025. Contrarily, the accused has claimed before the Honorable Court that he had been residing in the United States of America since August 2025. due to the miscarriage of his daughter. The activity of his mobile number during the said period directly contradicts his claim, thereby casting serious doubt on the truthfulness and veracity of his statement, Lordship. And now the case is still pending for further investigation, Lordship.
Can I just give a quick reply? My lord, my learned friend said that address is not known. Please see at page 17. Please see 17 of my IA 2 of 2000. Please see IA.
What is that?
Please 17. My email. They said that there is no address which is given. By email, please see at page 17. Full address. Kindly see down below contact details.
Okay, address is given.
Then
contact detail is given.
Then all details, my number.
What is revealed here is that CDR revealed that. You mean to say that he is not in the USA?
He is not in the US. As far as CDR is concerned, Lordship, from the CDR, it appears that the accused remain active till 18/10/2025. That is 18 October 2025, Lordship.
Where the location shows?
Location. Location shows, Lordship, remain active till 18/10/2025, which indicates that, Lordship, the accused person resides in India, Lordship.
No, where it says?
Lordship, here.
It doesn't indicate. Active means
Lordship.
If one goes to USA, will it not remain active?
Lordship, that is the technical things which I am not aware of,
He
Lordship.
has not indicated that he was remain active in India or somewhere.
Lordship, that what
it's not there.
It's not there, but what is clearly from here, it transpires that till 18/10/2025.
That is why I'm saying.
Lordship.
Does it mean that it will not remain active if it is taken to America?
Yes.
Lordship, since that is the technical things, Lordship, since to that extent, Lordship, since the statement itself is very vague, if you go by the CD.
My lord, I'll give an answer to it immediately.
Yes.
One answer I have given the contact, my contact I have given them. See the main petition at page 42. That's why the court has looked into it. See my main petition at page 42. There is an answer to it. Your lordship has rightly asked. See 42, my main petition 42.
Page 42.
Yes. See 42.
What is that?
This is my ticket. See my ticket, my lord. I have annexed. That is why the Honorable Court has said, see, Milan Shah passenger, kindly see, is a Qatar Airways. See, on top passenger, Milan so and so. Lordship got it, my lord? And please go down. This is dated when he has traveled Doha so and so, 6th of September 2025. Doha to US. Kindly see the Doha to Houston. These are, my lord, the court has looked into it. I know, my lord. That's why I have annexed the etiquette. Today they have come up and said I have not given the contact. I have given the US contact. This is my ticket. Where I will flee, my lord? I have given an address to them, my lord. That is why the court has passed an appropriate order. Your lordship is right. Why my mobile will not be inactive, my lord? We go abroad, our mobile is active all the time. Kindly see, my lord. Two things they have said. One is my contact. Your lordship has seen email, I have given the contact to them. Second is I have traveled US. And that too on 6th of September 2025. So today what, my lord, the end of the day, my statement should be recorded. I should cooperate through virtual mode. So let them comply, my lord. I have given the address. That is why I have come with an IA, my lord. If I would have not cooperated, then what, my lord? I would have taken time after time.
Okay, hard, Mr. Didas, Land Senior Counsel, assisted by Mr.
Idas,
Land Counsel for the applicant. Stava. Also had Mr. V.G. Momi, Land Public Prosecutor for the state of Nagaland. Miss Esther.
This is not because because in between us and police, my lord.
Okay, okay, not
Item
IA,
28
sorry.
is a party.
Okay, just
29.
Okay,
29 is a party.
By an order dated 10/12/2025, passed in criminal petition 43/2025. The investigating officer was directed not to take any coercive action. While directing the investigating officer not to take any coercive action against the petitioner, the petitioner was directed to extend his cooperation with the investigating officer in the case until his return from US. He was allowed to be interrogated or his statement be recorded by the investigating officer through virtual mode. However, it is further provided that the investigating officer will also make inquiry in compliance with Section 35(3) of the BNSS after his physical presence before the investigating officer, preferably within the first week of February. By this application, the Lana Senior Counsel for the applicant. Yeah, just a minute. By this application, interlocutory application, the petitioner prays for. Okay, just a minute. The Land Senior Counsel submits that till date, although he has communicated by
16 December and 10th of January, page 17.
Just a minute, page 17.
Although 9th. You see, Lordship, will you see page 17?
Also, although the applicant petitioner has conveyed
16th of December 25 and one is 9th of January. Reminder. If your Lordship see at page, my statement I have made in paragraph 3, kindly see paragraph 3, very detailed statement I have made, paragraph 3 at page 4. And thereafter, reminder.
Okay. Okay. Submits that after passing of the interim order dated 10/12/2025, the applicant wrote an email dated 16/12/2025 to the officer in charge, Suburban Police Station, Dimapur, along with a copy to the Nagaland Police communicating the order dated 10/12/2025, passed in criminal petition number 43/2025 by this court, and also requested for recording his statement through virtual mode as per the direction of this court. However,
second follow-up, paragraph 4.
And as no reply was forthcoming from the police authorities, the applicant again on 9/1/2026 wrote a follow-up email requesting the officer in charge, Suburban Police Station, Dimapur, for recording his statement through virtual mode as per the direction of this court. However, till today, no response has been received from the police authority, nor his statement recorded. Stop, huh? By filing this interlocutory application, the applicant pray for compliance of the order dated 10/12/2025 passed by this court in criminal petition number 43/2025 and or dispensation of the notice under section 35(3) of BNSS. No, just a minute. Your prayer is to?
Yes, to modify para 9. See at page 8, to dispense and to modify para 9.
And to dispense and to modify para 9 of the order dated
10/12/2025.
10/12/2025 to the extent.
Yes, to the extent that my first the virtual
That-
virtual mode,
that first
my statement may be
his
recorded.
statement may be recorded first by virtual mode and
Till
thereafter-
then, my lord, till then this
and until then
this physical,
the
my physical
till
appearance will
then
be
the
kept in abeyance, my lord.
physical presence of the applicant before the investigation officer
May be kept in
may be
abeyance.
kept in abeyance.
Yes.
Stop. Para. So this can be allowed otherwise, because first, provided he gives the proper number. Okay? Okay, Mr. Vijimomi, Learned Public Prosecutor.
My number has been given also. Your lordship can note down
No,
that at page 19. Page 19 it is. 17, my lord. See the same email, page 17, my lord. My contact number is given. Contact details.
Okay,
You want
alternate number also.
Alternate number also? Yes, we will provide.
Okay.
My lord will kindly note down the contact details and also
where,
at page 17.
Page 17. We'll record this.
Yes, yes,
in the
please
order
record
itself.
that. Page 17.
Okay.
Contact details. Page
No
17.
objection, provided the applicant provide the present contact detail with alternate number, okay, to the police, the IO investigating officer for recording his statement through virtual mode, okay?
My lord, can I just suggest one thing?
Yes.
That my learned friend can also give us an email of the suburban area so that we can also provide to the client also their email. Their link.
Because email he is writing, probably why they are not replying, we do not know. So probably received or not, we do not know. So police can also provide, of course, email
link.
so that communicate.
link to us.
And then after connecting the link, then you see probably maybe police is difficult to find his number connecting. So in order to ensure that, because virtual mode, let the virtual mode be completed first. Okay.
Yes.
Okay. In view of the above, in view of the above submission of the Land Council for the parties, the Land Council for the applicant and the public prosecutor, the prayer. This court is of the view that the prayer prayer of the applicant can be allowed. Accordingly, accordingly, the
Statement of the petitioner can be recorded through virtual mode.
the investigating officer shall first record the statement of the accused petitioner through virtual mode.
Till then, my lord, my physical presence may not be kept in abeyance, my lord.
And
also.
till then, the physical
Presence of the
applicant, accused.
maybe kept in evidence.
Applicant.
May not be required, my lord. May not be required. Yes, yes, I'll provide.
Is this,
Or maybe dispense 35. Physical presence will be better, my lord. Because
Physical presence of the petitioner,
accused may not be required at this stage.
Okay. Physical presence of the accused petitioner before the investigating officer.
May be kept in evidence.
Shall be kept in evidence.
Yes. My lord, your lordship can.
Physical presence as mentioned in para 9 of the
Yes,
order dated 10/12/2025 shall be kept in evidence.
Yes.
Okay.
I'm deeply obliged.
Okay, stop.
I'll give an alternative also. No, but yes, sir. We'll give immediately your alternative also.
We'll record in.
Yes, please, please, my lord.
The
300. My lord, can record the alternative number we have given client. I'll just give it now also in presence of the court. Its alternative number is 98300.
Okay.
Please note down, my lord. In
Okay.
addition to that,
Report it,
plus 91.
The alternative number, sorry, the
My lord, can note down in addition to the contact number which is given, in addition to that, we are giving an alternative number. Because it's in US.
Okay. In addition, in addition to the contact number of the accused petitioner, which is the number?
That is page 17, my lord. Page 17.
Which is the number? Where do I?
You'll find it IA, my lord, 17. Contact details US. See, my lord, respective sir. Page 17.
Contact detail.
Yes.
Given.
Address, WhatsApp number. Lordship got it? Page 17.
Page
17.
Annexer B.
Annexer B. Yes, correct.
Annexer B.
Contact detail US. Address 117 Dorothy Annie Way so and so. Phone WhatsApp +1 408 781 7962.
Annexer B of the intellectual application address. We need to record this in the order.
I think contact details, if you mention it better, my lord. Contact details.
Okay, contact details of, okay. We have to write all this.
Only contact the US address 11723
Okay,
Dorothy.
address 11723 Dorothy
Anyway
Cupertino CA 95014.
There's phone WhatsApp
WhatsApp
plus
+1 408
781
7962.
And email is this, my lord.
Email.
Yes.
MASH Masha 35
at the rate
hotmail.com.
And please take an alternative number also.
And the alternative number
is +91
is +91
98300
98
300
300
42251.
42251.
Yes, this is alternative.
Okay.
This is an Indian number, so.
Okay. Then this IA?
No, let it be IA be remain, my lord. We don't know. Let the IA remain.
Okay.
Because, my lord,
Then,
what your lordship can do it with greatest respect if it is not difficulty. So let this matter come up on 28 so that my learned friend can inform the court. Because I want that maybe it is free, my lord.
Okay. So then, para list is
29, my lord. 29 of this month.
As requested, let this matter be listed on 29
of this month.
Of this month?
Yes. So that he comes up and tell the court that your statement has been recorded.
Okay. 29.
10 days, my lord. 10
Okay,
days are
okay.
there. My learned friend appears for the complainant in the main case.
And in the main case, huh? And in the main case,
Main case will be listed on February, Lordship.
February?
9. Yes.
No,
I'm
let
seeking
it
for 3
come.
weeks.
Thereafter, let it come on that day. Thereafter, your lordship can fix it, no problem. Because main case has to be there. Your lordship cannot take an IA without the main case. There
so
is
in the,
already
in the main
interim
case,
order.
we'll just fix it on?
On 28 itself.
28?
29. 29.
29 may be difficult, your Lordship.
When?
You can take time.
February?
February 9.
February 9?
Yes, your Lordship.
Then both will be fixed on February 9 only?
No, that will be difficult. Again, first week, my lord, presence, my presence. So I want that.
No, first week your presence has been dispensed
I know.
for the time being.
That's right. No, that's what we want. The statement should be recorded. Somehow
Statement
it
will
is not.
record it within, I think,
I
short
don't
period.
know. My lord, what I want, that I want a clear cut. So let this what I request, the 28, at least I inform the court also, that order is passed. Let this matter come on 28. My learned friend can take time. There is absolutely no problem. Can they take time on that day itself? IA can be disposed of on that day, my lord.
That's okay.
IA
I'll
can be
counsel.
disposed of.
On 28?
Yes, IA.
Okay. Assisted by IDAS, Dana Council for the Petitioner. Also had Mr. Vijay Zimomi, Dana Public Prosecutor for the State of Nagaland. Okay.
29.
Miss Esther, Dana Council, would appear on behalf of the respondent number 2.
Yes, you are true.
Yes, your Lordship. 2.
Not yet filed Wakalatnama?
Not filed.
And prays for some time to file Wakalatnama. Okay, the prayer is allowed. This is prayed for, is requested by the parties. Let this matter, by the petitioner, let this matter be listed again on 28.
29.
Sorry, 29.
Yes. There is an interim order in the main case. No,
The
court that will
interim order
continue.
passed earlier shall continue till the next date. Till then, okay.
I'm deeply obliged. I have taken some time, my lord,
No, no,
to make.
that was necessary.
Okay. Alternative number I have given you. Yes. Please come on. I want to recognize it.
I think I gave you this one. Yes.
Okay, this is Itanagar bench.
Yes.
For bail hearing, item number 1, Itanagar bench.
May I please, Your Lordship,
Yes.
this is a bail application, Your Lordship. Basically, I have raised the issue that the ground of arrest was not communicated to the accused person, Your Lordship. Which is at page 22 is the arrest memo, Lordship.
Just a minute, huh? Is it POXO Act?
Lordship.
Okay, why it was fixed on 19 then?
Your Lordship, there was an issue with regard to ground of arrest, Your Lordship. Your Lordship was kind enough.
Issue with regard to what?
The ground of arrest.
Oh, ground of arrest.
Yes.
Yes, Your Lordship.
Okay, so
Your Lordship was pleased to grant me some time to do a research on that, Your Lordship. Your Lordship, I have done my research and I concede with my learned friend that because the case that I was relying was prior to Mihir's case, Your Lordship. Mihir's case clearly defined that even when the charge sheet is filed as well as when the cognizance is taken, it shall not vitiate that a person should not be given the ground of arrest, Your Lordship. Since in this case, the ground mentioned in arrest memo, there is no ground mentioned in the arrest memo, Your Lordship. I hereby concede with whatever my learned friend is submitting, Your Lordship.
okay, when he was arrested?
Lordship, I am arrested on 26/2/2025, Your Lordship. Page 22 is the arrest memo.
Okay, okay.
And Your Lordship's own judgment, Your Lordship, in one of the bail application number 26/2025, which I have already provided, Srimati Amalina Pradhan. That case was also of the POXO, wherein the ground of arrest was not communicated. Your Lordship has granted the bail.
So similar case?
Similar, exactly. That was also under POXO Act.
Okay. So hard, Mr. Abid Kumar Singh, Client Counsel for the petitioner. Staff also had Mr. Pijini, Naran Additional Public Prosecutor, Arunachal Pradesh, appearing on behalf for the state respondent. State respondent, huh? Whether the and who represent the respondent number 2?
I'm representing respondent number 2 for victim.
Okay. And Mr.
Pramod Kumar Gaur. Pramod Kumar Gaur. Pramod Kumar Gaur.
Pramod Kumar
Gaur.
Gaur. for representing respondent number 2. This is the case of the brother and sister.
Yes, 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 Lordship.
Okay.
If I may, Your Lordship, Lordship, since we are not into the merit of the case, Your Lordship may reflect that only on a technical ground, Your Lordship.
Yes, 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 yes. That is there.
This application has been filed under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for release of the alleged accused who has been arrested in connection with ITA WPS case number 03/2025 under section 137(2)/87 of the BNS, read with section 6 of the protection of children from sexual offense. Stop, para. The case of the petitioner is that based on the
missing report
lodged by one Sorang Tajak.
Yes, Lordship.
On before the officer in charge, Women PS case, Women Police Station, Capital Complex, Itanagar, on 31/01/2025.
Informant Pajak.
The PS case was registered. Initially, the ITA WPS case number, same number. WPS.
Yes, it was filed before the Women Police Station and the
137(2) BNS, and subsequently under section the same section, same only, I think.
Yes.
And section 6 was added.
Section 87 of BNS was also added. Subsequently, section 6.
Subsequently, section under section 87 of the BNS, read with section 6 of the Protection of Children from Sexual Offense Act 2012 was added. Okay. Stop. And added, and the accused was arrested. When he was arrested?
26/2/2025, Your Lordship.
Arrested on 26/2/2025. And since then, he has been languishing in judicial custody till date. Stop. Para.
Yes.
Earlier, how many bail applications moved?
Prior to this, two. Before this, Honorable, before the High Court once, and prior to that, once.
Earlier,
special court.
One bail application was moved before. One bail application before the Special Judge POCSO Act UPA, and another one before this court.
This court, Your Lordship, this Honorable Court.
Were moved for praying for release of the accused on bail. However, the same were rejected When the trial court was rejected?
On 37/25.
On 37/2025, and by this High Court?
On 5/9/2025.
And 2025 respectively. Stop. Para. This is the third subsequent bail application seeking release of the accused. In this bail application, the petitioner seeks bail mainly on the ground that the mandatory requirement of, within inverted comma, communication of the ground of arrest to the accused, inverted comma close, at the time of arrest was not complied with, and therefore such non-compliance amounts to violation of Article 22(1) and 21 of the Constitution of India, and also Section 47 and 48 of the BNSS. Stop.
Yes.
The Land Council for the petitioner submits that though arrest memo records and general reason for arrest were issued, comma, the prosecution records do not show that the specific ground of arrest were furnished in writing to the accused or his family at the time of his arrest as mandatorily required. Stop. Para. In support of his contention, the Land Council for the petitioner has relied on the following judgment of the Honorable Supreme Court. I'll give you the Vihan Kumar versus State of Haryana. This para 7 I'm giving you. Para 7, Vihan Kumar versus State of Haryana, reported in 2025 3 Supreme 36963 semicolon 2025 0 Supreme SC 283, comma, whereby the court reiterated the right under Article 22(1) is a fundamental right and its violation invalidates the arrest and consequential remand. Stop. Number 2, Praveer Purkastia versus State of NCT of Delhi, reported in 2024 Supreme within bracket SC 463, wherein it was held that non-compliance with the constitutional mandate to inform the arrested person of the grounds of arrest vitiate the arrest itself. Para. The Land Council for the petition further submits that upon submission of charge sheet, were the charge sheet submitted?
Yes, Your Lordship.
The trial is going on, Your Lordship.
The trial of the case has already begun. How many prosecution witnesses recorded?
Only one.
And victim has already recorded?
No, Lordship.
Okay.
No, Your Lordship.
Informant record.
And the sum of the witnesses has already been examined. Informant already recorded?
Yes, Your Lordship.
Including the informant. And the case is pending for examination of the rest of the witnesses. Therefore, we come, inverted comma, semicolon, therefore, comma, the custodial remand of accused is no longer required for trial purpose. Stop. Para. The Land Council for the petitioner submits that non-mentioning of the ground of arrest while issuing the arrest memo or the notices under Section 47 and 48 of the BNS itself amounts to a violation of Article 22(1) of the Constitution of India, comma, hence, comma, even without entering into the merit of the case, comma, the present accused is entitled to bail. Entitled to be released on bail. Stop. Released on bail in view of the decision in Vihan Kumar versus State of Haryana, Supra, and Praveer Purkastia versus State of NCT Delhi, Supra. Para. The learned additional PP was directed to produce the obtain instruction and to produce the status report as well as the scanned copy of the trial court record. Staff.
Your Lordship, I'll just correct Your Lordship. Lordship, the registry was directed to Your Lordship.
Register, okay. Okay. Then just a minute. The registry was directed to call for the trial court record. Okay. Based
Yes,
on based on the record, the learned additional PP fairly submits that the ground that at the time of his arrest, the accused and the family was not communicated. They communicated the ground of his arrest. Therefore, she fairly conceded the submission of the learned counsel for the petitioner that the mandatory requirement was a requirement at the time of arrest of the accused was not complied with by the arresting authority. Stop. Para. The learned counsel appearing for the private respondent number 2 also fairly submitted that since the mandatory requirement of communication of the ground of arrest of the accused was not complied with at the time of his arrest, he has no objection if the bail is granted, if the accused is released as prayed for, comma. Para, I have considered the submission of the learned counsel for the appearing on behalf of the parties. Stop. Para, the arrest memo available on record shows only general reason for arrest, comma, but there is no material to indicate that the ground of arrest were furnished in writing to the petitioner, sorry, to the accused at the time of his arrest or soon thereafter. Stop on para. The Honorable Supreme Court in Pankaj Bansal versus Union of India has categorically held that communication of the ground of arrest must be in writing, comma, oral or verbal communication is not sufficient. Oral or verbal communication is not sufficient. Stop. Non-communication of such grounds at the earliest opportunity vitiate the arrest, and subsequent supply does not cure the initial illegality. Stop. Para. A bare perusal of the case record and the memo of arrest reveals that no proceeding of the ground of arrest was made or explained to the accused person. Stop. Para. The Honorable Supreme Court in earlier, Prabir Purkasta versus State of NCT of Delhi, Supra, and Vihan Kumar versus State of Haryana, Supra, has clarified that non-compliance with the mandate of Article 22(1) renders the arrest unconstitutional and illegal. Stop. The consequences of such illegality cannot be brushed aside lightly. Stop. Para. Though the offense alleged against the accused is grave, however, in light of the above discussion and decision of the Honorable Supreme Court, this court is inclined to allow the bail application, not on the merit of the case, but solely on the ground of violation of the constitutional and statutory right of the accused person at the time of his arrest. Para. Accordingly, the accused, what is his name? Sorang
Talo.
He is directed to be released on bail subject to the following condition. 1. The accused shall be released on furnishing bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the learned trial court. Stop. Next, the accused shall appear before the trial court on each date and the date the trial is fixed and shall cooperate with the trial case. Stop. Next, the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case. Stop. Para. The bail application stands disposed of in terms of the above.
There is a small prayer, Your Lordship. Your Lordship, seeing the severity of the case, Your Lordship will see that the informant is the father, Your Lordship. The victim stays with the father, Your Lordship, and also the accused is the son, Your Lordship. If if there is an specific mentioning of that the residential of either of the victim of the or the accused, Your Lordship, because if they're biological siblings, Your Lordship,
See,
and they'll be saying
private respondent who represent the victim's father and the victim doesn't have any objection here in this case.
yes, Your Lordship. But then taking into consideration that it's also a POXO case, Your Lordship, the father in this case is not seems to be neutral person as such, Your Lordship, because both of them are deeply related to him, Your Lordship. Because because in such cases, Your Lordship can also direct that rehabilitation of either of the victim of the accused may be taken into consideration, because also
but the accused is major.
yes, yeah, but the victim is my minor, Your Lordship.
Victim is minor. In that case, what do we do? Victim, see, since February 2025, now probably she has become major, it appears.
She's 11 years.
Yes, I think.
Oh, she is no, she's married. What is her age?
When during the filing of the FIR, which was filed on 18/3/2025, she was only 11 years old, Your Lordship.
Not 11 years, probably, because she was
It's in the.
What is the age of the accused?
Lordship, as per a statement given before the learned magistrate, she stated that her age is 17 years old.
In which class she was reading or she is reading? She is studying, huh? Is she going to school?
And in some of the documents, I think 11 years, 13.
Private respondent would be able to tell.
Yes, Lordship. Okay.
She discontinued the school. She discontinued the education because this.
In which class she was studying? Her age certificate probably was collected from the school.
Yes.
And probably in the school.
Before the second court.
What is the age of the accused, Mr. Singh.
Age of the accused. Age of the accused.
No, as per charge sheet.
Your Lordship, if Your Lordship come to page number 24, Your Lordship, which
Then
was
in
during
the
investigation.
last in the condition, considering the age of the victim, the learned special judge shall pass necessary order. Will it be okay in the bail application?
No, Your Lordship. I'll just point out, Your Lordship, the original birth certificate of the victim was collected and her date of birth was shown as 7/1/2024, Your Lordship, which is 11 years at
In
the
that
time.
case, Your Lordship, a condition
that's
may
a
be
dispute.
imposed, saying that
That's a dispute that can be decided on the later stage when the application for age is disputed, Your Lordship. My concern only with this present application is that
What condition you want me to put? What
Your Lordship may direct the Child Welfare Committee also, Your Lordship, to if the victim can be rehabilitated, Your Lordship.
In the bail application, is it okay?
Accused person
That can be done, Your Lordship, because while giving the condition, Your Lordship Your Lordship has clearly stated that
So,
it
considering the age of the victim, the learned special judge POCSO Act shall pass necessary order to refer the victim to refer the victim for rehabilitation. Okay, is it okay? At the
Your
time,
Lordship, the age is not age is not being disputed that she was not a minor, Your Lordship.
No. That is why I am saying, considering the age of the victim, will refer to the CWC.
Yes, Your Lordship, but then since the BA is being
to refer the minor victim to CWC.
In fact, if I may pray, Your Lordship.
Proper rehabilitation.
Yes, Your Lordship, in this bail application condition itself can direct the CWC to verify the situation and if proper, if rehabilitation of the victim is necessary or not, Your Lordship. They will decide if it's necessary or not, Your Lordship.
Then considering the minor age of the victim, directly to CWC. No, we can only direct.
Your Lordship can directly to the CWC, Your Lordship. There is no issue because from the time of filing of the bail till the trial is completed, Your Lordship, CWC's assistant can be taken at any point of time, Your Lordship.
That can be. That can.
Judge POCSO Act shall pass necessary order directing the CWC to ascertain the condition, the present condition of the victim girl, if rehab victim girl for her rehabilitation. Okay?
Yes, if necessary, Your Lordship.
If necessary. Huh?
Your Lordship may kindly, in that case, may direct me to hand over the order of this Honorable Court before the Special Court, Your Lordship.
The learned additional PP shall communicate this or a copy of this order to the Special Judge POCSO Act and also a copy to the CWC. Okay?
Yes, sir. Yes, Lordship. Deeply obliged.
Highly obliged.
Yes.